experiences from other countries, which is going to be interesting. It's interesting. First of all, as you've seen, this session is being recorded. If someone doesn't feel safe, we are not gonna use it. But if you don't mind, some of the insights you are gonna give us are very interesting, and we would like to use it, but only if you let us do it. So if you could write your authorization to the Asociación Judicial Francisco Vitoria, the email where you receive the link, that would be amazing for us to do some publicity of this session, but in a way that is productive. If you don't feel comfortable, please just say so. Well, just don't say so. Don't send the email. That's easier. And we won't use any of the footage where you are speaking. Is that understood? I guess, right? So, first of all, I would like to start by my colleague Carlos Cardenal, who is going to answer some of the questions that we've given them before this, not to cock them out of guard. So, Carlos, what do you think is the current situation in our country about independence when it comes to the appointment and selection of judges, prosecutors, and court presidents?
Well, first of all, I'd like to thank you all for being present and for giving me the opportunity to participate in this debate. I think that in Spain, at least, one should make a difference between court presidents and Supreme Court judges and the rest of them, because the normal procedure in order to become a judge is to pass a set of very, very difficult exams, which people normally spend 4 or 5 years even studying for them. Then one has to do 1 year at the Spanish judicial school, and then a period of traineeship with more experienced judges. And then one becomes appointed as a judge and can pick the first post according to their grades. And from that moment on, whenever a judge would like to transfer to another court, one asks for it, and the system is based strictly on seniority. So there's no way to meddle, about or on whether a judge should be transferred or moved to one place or to another court. However, court presidents and Supreme Court judges are appointed by the Council for the Judiciary, which has, in this regard, very, very wide discretionary powers. And the way in which the Council for the Judiciary is chosen, or their members rather, taints the appearance of impartiality of the people that the Council for the Judiciary appoints for the Supreme Court. I'm not saying that the members that are elected, the judges who are elected for that court, the Supreme Court, aren't impartial or aren't independent, but the truth is that their appearance of independence might be challenged by the way in which the Council for the Judiciary is, in its own turn, chosen. But I think we will talk about that later, so I'd rather not develop on that just now.
Adrian, what is the same situation in Hungary?
Hello, everyone, and thank you for having me. In Hungary, it's somewhat similar, somewhat different. We have more or less the same system for applicant for the appointed for the first time, or when a judge who is already appointed wants to get promoted or wants to be transferred to a higher court or to another court, another part of the country. It's a quite complex application process in which one has to get points, has to collect points according to the university or the degrees they collected during the trainee time, and after that what kind of other skills they have, like speaking languages or published essays or things like that. And with these points, they go to the to the not the National Judicial Council, but the Council of Judges at the court he's applying to, and they can give them some extra points, and then they make a ranking. And after this, the judges for the first time are appointed by the President of the Republic. After that, the promotion and the transfer is decided by the head of the NOJ, which is the National Office of Judiciary. And it's not the decision of the council, but it's a decision of the head of the office. And that's somewhat a problem, because the head of the office is appointed by the parliament, which is a political status. And it was heavily criticized when this system was built up in 2012, I guess. And now it's a bit modified, so that if the head of the office wants to appoint someone who is not at the top of the ranking, but on the second or the third place, they have to have the consent of the National Judicial Council. So it's a bit more strict, and there is a bit less room for misuse. But it's still quite a large power in the hand of the head of the NOJ. And with the presidents of courts, and with the president and with other court leaders, they are also appointed by the head of the office. And it's also that if there's a court, the judges of the court vote, and if the applicant does not get the majority of the votes, they still can be appointed, but only with the consent of the National Judicial Council. So a little bit less power than at first, but still very much power in one hand. And this hand of the office, which is not elected by the judges, but appointed by the parliament. So that's something we are not really satisfied with. And there were quite huge fights with the European Union. You may know about this. And now the system, at least in terms, at least in words, is sufficient for the European Union. They say that it's okay because there are quite a lot of balances, so the system can work well, or there are not so much room for misuse, but we are still a bit hesitant about it. The powers of the National Judicial Council is a big question here, but I know that it will come later, so I give the floor to Marek. Thank you.
Thank you. That's so interesting. As we are not so many, does anyone want to add something about their country, or any question about this topic we already discussed?
Yeah, if I may, I'd like to ask Adrian about whether the points that a judge gets for publications or for having a master's degree, are they like very strictly set, or is it just a question of, I can take all of these into account more or less freely, like how precise is that taken into account?
It's quite precise, actually. The problem is that there are more points to get by, these extracurricular activities, like another degree, or speaking, I don't know, 4 languages, or publish essays that is not strictly connected with being a judge. And one can get more points for this than the one who has been working at a court for, I don't know, 30 years, and does their work, do their work quite honestly, but don't have the time to collect other points, and then they stand no chance against someone who maybe hasn't worked at all at a court, or just a very short period of time, but did collect quite a lot of points. So that's a problem. And so-called subjective points given by the council cannot balance this. So it happens quite often that the applicant with the with the major experience and really fit for the job will be overruled by someone coming from the outside with quite a lot of points. So that's a problem, and our National Judicial Council is working on it. So they want to reach that the parliament modifies these rules, that it's okay with these extra points, no problem with that, but they shouldn't be so
Heavy,
yeah, so that they should be a bit more balanced, but there is no real will on behalf of the parliament or the government to change these rules, so I don't think they will succeed.
So thank you very much again, Adrian. How is the accountability of judges and prosecutors, including disciplinary regime and bodies and ethical rules, judicial immunity and criminal or civil liability of judges in your country? This time, I think we should start with Adrian, just to keep you updated all the time.
Yeah, okay. So with the disciplinary procedure, I think we are okay. So we have a very good system, and we have a separate court for disciplinary procedures, but they are elected from among judges. So they are judges, and they are not court leaders, they are not members of the council, they are independent judges who form a court for disciplinary procedures, and they work okay, I think. So just a minute over this. So I think on that part we don't have real problems. The other thing about the ethical rules, I can say that we have a code of ethics, and we've had it for some time already, and that was not really specific, that there were not really specific rules, and the National Judicial Council adopted a new code of ethics in July 2022, and it's quite good in my opinion. But the president of the Curia stands for the Supreme Court. The president of the Curia challenged this code of ethics and the one specific rule at the Constitutional Court, and this is about freedom of expression of a judge, because the code of ethics says that a judge may express himself or herself about I want to just a minute. I would like to express his or her opinion, to publish and to lecture or to teach about law, the legal system, and the administration of courts. And that's what the president of the Curia does not like, and he says that this is unnecessary and this is against the constitution, and so he challenged this rule at before the Hungarian Constitutional Court. It's not decided yet. What we think is that that's a good code of ethics, and this article specifically is very important for the judges, because now it's not decided. A judge who wants to teach at a university or just hold a lecture or publish something does not know what he or she may or may not do, and this mere fact already has some kind of chilling effect on the judges and on the free expression of judges. So we, and by we I mean Res Judicata, because I am a member of the board of Res Judicata as the judicial association, and we made a contribution to. There was a case before the European Court of Human Rights, and there is some follow-up procedure at the Council of Europe, and they examine if there is a chilling effect above the Hungarian judges, and we made a contribution to this procedure about this specific article of the Code of Ethics, and they agreed that this can be a problem, that the mere fact that it is not decided and that it is challenged, and quite a lot of judges say that, oh, it's okay, then I rather be silent. I don't say anything. It's not so important for me to publish things or to express my opinion in I don't know, not a newspaper, but in an article, or to go and hold lectures, because it's not my job, and if it's risky, then I don't do it. And we think that's also a task for the judiciary. It's a responsibility, where there's the society to spread our knowledge and to talk about the importance of the judicial independence and rule of law and everything. And there are quite a lot of colleagues of mine who agree, but they don't want to risk their promotion or their career, which is only understandable.
Yeah, definitely. So, what about Spain, Carlos?
Well, in Spain, the General Council for the Judiciary adopted the ethics code also in 2016. And there is a commission ethics, which is elected by the judiciary itself every 4 years or every 5 years, I think. Although, you know, this ethics code and the decisions, the decisions that the ethics board reaches are not binding, in a sense that they don't have any effect with regard to disciplinary proceedings, for example. And that is made very clear by the ethics code itself. You know, like, this ethics code must not be used, you know, in terms of disciplinary action against judges. It's just a board that every judge may appeal to, asking about a question of ethics, and then they provide their answer, and the judge may or may not, you know, abide to that opinion. It's not binding. With regard to disciplinary actions, that is dealt with primarily by the Council for the Judiciary. There is a person in charge of promoting disciplinary action within the Council for the Judiciary and conducting the investigation, and then even proposing to the Council whatever sanction may be applicable. And of course, the decision by the Council for the Judiciary may be challenged before the Supreme Court. So there is a judicial control over the disciplinary proceedings of the council. And about criminal and civil liability of judges. Well, criminal liability of judges is set in the Spanish Criminal Code. So that is decided over by judges, of course, of the criminal branch of the judiciary. And then civil liability is also applicable, although, first of all, the Supreme Court must ascertain that there has been a judicial error or a judicial mistake. And after the Supreme Court has decided that, then the affected person may initiate that procedure before the Ministry of Justice, in order to have their compensation. And then only in case of very, very gross negligence or even, you know, conscious malfunction may the state then ask the individual judge for those damages in return. So that's broadly the system. There has been criticism about the procedure which the council uses for their disciplinary action. It has been said that it can be quite opaque, that it is not sufficiently well regulated or very precisely regulated. But I don't think that as of today, that is a very, very big problem within the Spanish judiciary. I think we have other much more pressing issues which will come up later.
Okay, thank you. Adrian, do you have a body task with safeguarding the independence of the judiciary? Like, for instance, in Spain, we have the General Council of the Judiciary. And in that case, How are the members selected? Do judges participate in the election for its composition and nomination? Is there any issues about dismissal of these members? And does this council have its own budget to pay judges, or is another organ of the government who is in charge of the salaries of the judges?
Thank you. That's quite an important issue for us right now. We have a National Judicial Council, and it's elected among judges, by the judges. It has 15 members. The 15th member is always the president of the Supreme Court, but the other 14 members are elected among judges. And this is quite a complicated election procedure. And we are right now after the procedure because it happens every 6 years. All the members have 6 years of mandate, and there is no rotation. So the whole council ended their mandate this end of January, and we had these elections during the autumn, and it ended in January, and we elected the new 14 members, and we have some problems with it. There were some modifications in this regard too. We had a modifying act on judiciary in July last year in order to get the EU money, to be short and simple. And one of the expectation was to modify the powers of the National Judicial Council, the possibilities and everything. And what we wanted, and we thought that it would be essential that court leaders should not be appointed to be members of the National Judicial Council, but because the whole point of the council, the main task of the council is to control the head of the National Office of Judiciary, so the head of the NOJ. And court leaders who are appointed by this head of the NOJ shouldn't sit in the council because it's impossible to expect that they could be impartial and they could do their job properly. This did not go through, so it's possible to elect a court leader into the council, and it indeed did happen because one of the 14 became a court leader. So that's not so good. We expected way worse, so it's only one. That's already a result. It's already something. So that's the council, and the modifications, the changes last July meant that the council has more and more power in order to control the head of the office, and that until then the office did not have an independent budget and did not have an independent office and staff and everything. Now they have this. They have a separate budget. They are not dependent from the head of the office anymore, and they have an elected president and vice president among themselves, who is like an employer for the staff of the council. So they work really like a real office. Now they have the possibilities, and they have other rights too, like they can ask for specific data from the president of the Supreme Court and from the head of the office, personal data too, because in the past it was several times denied these data, and they could not fulfill their jobs in controlling the activity of the head of the office if they didn't get the data to do so. So now it's already mandatory to give the data to the council, and if it's sensitive, it's personal, then of course they have to keep the secret, but they are entitled to get these data. And yeah. One other thing which is important, it's quite a lot of job, and until then, until July, it was up to the president of the courts, where these members of the National Judicial Council were, if they are allowed to work less in order they have the time to do their job as the members of the council, because they go on with their judicial work. And now it's in the law that they have to be they have to have some enlightened workload, so that they have time, like somewhat like a trade union. The representative at trade union doesn't have to work that much than other colleagues, and that's something similar, because it was misused a bit in the past. So that's better.
Okay, thank you. And what about you, Carlos, in Spain?
Well, I think that this is like the biggest issue in Spain and has been for a while now, not only among judges, but also for the public. And it's constantly in the press. And currently, we've reached a situation where the Commissioner Reinders has had to come to Spain and try to help us solve our own constitutional problem, which is, I think, I mean, crazy. But how everything stands is that in Spain, the Council for the Judiciary isn't actually in charge, according to the Constitution, of safeguarding judicial independence. It's not one of its functions, according to our Constitution, even though the reason for creating a Council for the Judiciary was to preserve judicial independence from the executive, especially. And the actual powers of the Council for the Judiciary to preserve judicial independence or to defend judges from interference are very, very scarce and very ineffective in practice. I think we could all agree on that. The council has 20 members plus its president, so they should be 21 in all. Those 20 members were elected at one point in history. The first the first Council for the Judiciary was elected in a different way than it is today. And I'll explain myself. The Constitution provides for 8 of those members being legal practitioners of different backgrounds, but not judges, so non-judicial members of the council. And those 8 judicial members should be elected by Congress and Senate, so by Parliament, half and half, by a reinforced majority of 3/5 of both chambers. And the other 12 members, according to the Constitution, should be chosen amongst judges. Well, the first system of 1980 provided that those 12 members that should be judicial members and be chosen amongst judges were to be elected by judges too. So the whole judiciary chose those 12 judicial members of the council. However, in 1985, so 5 years later, this didn't last much. The law was changed, and it stated, and has remained in this way, that those 12 judges were to be elected by Parliament as well, and divided between Congress and Senate. So that was challenged before the Constitutional Court, and the Constitutional Court, in a very famous ruling in 1986, so the year after the reform was passed, decided that the system was constitutional because the Constitution didn't say that those 12 judicial members should be or had to be chosen amongst by judges, but amongst judges. So, the law could decide how those 12 judicial members were to be elected, and it was licit, it was okay for the Parliament to be the responsible body for that, and no longer the judges themselves. However, the Constitutional Court, in a rather naive way, in my opinion, warned about the risks of this system. And the Constitutional Court said, well, political rivalries and political agreements, which may be licit and may be normal in other fields, cannot apply or cannot be applied in the field of the judiciary. So, okay, the system is fine, but the Council for the Judiciary cannot be made into a sort of third chamber, or the politicians should not replicate their own majorities in parliament in the judicial council. That is, of course, exactly what has happened ever since. Every political party, while in the opposition, and when they had less members in the Council for the Judiciary, all have claimed that the system should be changed, that politicians should not be allowed to mess that much within the Council for the Judiciary. So, we had to come back or return to the first system. However, all of them, and I'm talking about the two main political parties in Spain, so I mean, there's no distinction in this, when they have reached power and have had a majority in parliament, and the renewal of the Council for the Judiciary was due, they have all conveniently forgotten their promises or their speeches, and have always reached an agreement. Okay, well, it is now my turn to have a majority within the council. Next time it will be your turn, and we can all live with that. That system, however, kind of exploded in 2018 because of a scandal, a political scandal, some leaked WhatsApps, which were very controversial between politicians. And ever since, we have had no renewal of the council, because there is now a kind of a blockade or a situation in which the parties just don't get along very well and can't reach an agreement on the new members. So that's the current situation. And 5 years have passed since 2018, which is actually the term of the new council, or the would have been new council. The council is every year with less and less or fewer members, because the judicial members of the council retire, so they aren't renewed. The situation is quite critical. And that's the situation now. Now the Socialist Party, which is in power, wants to renew the council according to the current rules. They feel that it is their right, since they have had a majority and the law is, written in that way. So, they feel like the council must be renovated as it is. Now, however, the opposition party now says that the system is unacceptable and that they won't renew the members of the council until the system is changed and we are back to the first original system of 1980. There's the confrontation. And in the meanwhile, since the Council for the Judiciary makes the appointments for the Supreme Court, the Judicial Council has been deprived by a legal reform of its competence to appoint those Supreme Court judges. So the Supreme Court has now 30% of its posts vacant, and it cannot be renovated, because as a means of pressure, the Socialist Party and the other coalition party of the time passed this reform to prevent the council from making discretionary appointments until it is renovated. So, now the council cannot appoint new Supreme Court judges. They keep on retiring. So the Supreme Court is just being diminished and diminished and diminished. So the situation is really, really critical. It's starting to affect very seriously the normal functioning of the justice system. Many court presidents should have been also renewed and are still in their posts, and it's impossible to make those new appointments. So it's really starting to affect. I think that the numbers are something like the Supreme Court now does like 1,000 or something like that, fewer rulings every year than it should be, because it simply does not have members. So it has been even difficult to form the correct formation within the different chambers of the court, because there are not sufficient judges. So Some judges from other sections have had to, go and join other colleagues in order to make the formation of the court, because otherwise it would be impossible. So yeah, this is very, 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 very difficult, very critical. And well, I don't know what will come out of Mr. Reinder's mediation, but I must say, quite skeptical, and I don't think that any of the parties will make any kind of concession to the other. So we're blocked. We're blocked, and
Basically, that's to sum up. We're
yes,
blocked.
and we're blocked because of that fatal reform of 1985, which effectively gave power to Parliament over the whole of the Council for the Judiciary. And that's it.
Also, I would like to highlight the fact that because of this situation you just described, the length in the proceedings are getting awfully long when it's not necessary. I mean, justiciable must have their case resolved in a reasonable time. That's their fundamental right. It's blocked. So we are not just blocking the justice, but all the fundamental rights that are preserved by the judicial system. So thank you very much, Carlos. Is there any question about this topic for Adrian or Carlos?
My question's already answered, because I wanted to ask how do you function? How because 5 years, 6 years in the in a system that large, it's a very, very, very long time. So yeah, people retire, people quit, people have I don't know, personal problems because they want to change jobs, and yes, 5 years or 6 years can block a whole system. So yeah, this is very severe, very serious.
Actually, it's not that it's just a blockage. It's just that we are assisting to, we are basically witnessing something so surrealistic. Like no one could have ever thought in their wildest nightmares that this could ever happen, because it's like the crisis of the crisis of the crisis of the crisis. So it's like, so I mean, for me, surreal. I don't know for you, Carlos.
Yes, and I think it's absolutely dementia that we have had to ask, a European commissioner to come and help us with our own constitutional problems, because our politicians just aren't up to the job, I guess, or don't have the vision, to change things or to reach their own agreements. I mean, I feel like this makes us kind of an underage country, which can't deal by itself with its problems. And I actually feel quite ashamed that we have had to reach this point. And I also wanted to add, also because this has been the work of the Judicial Association, Francisco de Vitoria, that 6 of the judicial candidates, which were, meant to be elected or maybe be elected by Parliament at that time, at 2018, applied or filed a complaint before the Constitutional Court, alleging that their right to be elected to public posts was being violated, because the proceeding here and the issue is that Parliament had the list of the candidates. And according to the law, the President of Congress and the President of the Senate, each in their chamber, of course, have to take all necessary measures in order for the proceedings to continue and to reach their normal end. And of course, in order to do that, they have to call the vote so that the chamber may elect those members or among those candidates. And neither the President of Congress nor the President of the Senate have ever called the vote without any legal reason, because there was no legal reason for not calling the vote. This is a question of political parties and the presidents of Congress and Senate acting not very independently, but as envoys or, soldiers of their respective parties and party leaders, which I think is also very, very grave. And the Constitutional Court dismissed the complaint. They didn't even take it into consideration. They said that, you know, the issue didn't have enough constitutional relevance,
Ironically,
which I also find very, very surprising.
when the parliament is not fulfilling their task made by the constitution, but ironically doesn't have constitutional
Exactly.
transcendence.
So they dismissed the claim without even considering the actual grounds of the case. And then those candidates and the Judicial Association, well, actually the candidates applied or filed a complaint before the European Court of Human Rights, alleging that their right to due process had been violated because the Constitutional Court had refused to even consider the merits of the case. And the European Court of Human Rights has said that, in fact, there has been a violation of Article 6 of the Convention by Spain because of the actions of the Constitutional Court in this case. That ruling by the European Court of Human Rights, however, has still not been executed in Spain by the Constitutional Court. I guess the execution would mean to at least take into consideration the case and study it on its merits and then decide whatever, you know. But the court, I don't know the state of those proceedings within the court exactly, but that's the situation now. And, you know, I think that's also, well, a very, very meaningful ruling and against Spain in this aspect. Well,
And also I would like to add the fact that even the council has been deprived of its function to name discretionary appointments. Well, luckily for us, they were allowed to do this, to appoint the members of the Constitutional Court.
oh, yes. Because this story runs parallel to another one. I mean, we're full of disasters in Spain. So the Constitutional Court has 12 members, and they have to be renovated, 1/3 of them every 4 years. So it was the turn of 4 members of the Constitutional Court to be renewed. Those 4 members had to be chosen, 2 by government and 2 by the Council of the Judiciary in a discretionary way, of course. And they have to be appointed at the same time, you know, so the government can't choose their 2 members and the Council for the Judiciary, their other 2 members separately or in a different time. They have to decide, they have to be appointed together. Of course, since the law had been reformed in order to deprive the council to make any discretionary appointments, it turned out that it couldn't make the appointments for the Constitutional Court either, not only the Supreme Court, but also the Constitutional Court, of course. This meant that the government could not make its own 2 appointments. This was a problem for the government, of course. I mean, what government would want to refuse freely appointing 2 members of the Constitutional Court? So, of course, the law for the judiciary was again reformed to say that the Council for the Judiciary would not be able to make discretionary appointments except for the Constitutional Court magistrates.
Magically.
So finally, those 4 members of the Constitutional Court could be renovated. And that new Constitutional Court, by the way, has also said that the reform that deprived the Council for the Judiciary from making those appointments to the Supreme Court is constitutional.
Fortunately. Lucky us, our Constitutional Court ruled in favor of the Constitution.
Yeah.
Well, Adrian, I think we're speaking too much about Spain. So what about the prosecution service in Hungary? Does it have a hierarchical organization?
Absolutely, it is, and it's publicly so. So the head of the prosecutor's office is elected by the parliament, and he is responsible only to the parliament. He makes this annual review before the parliament, which accepts it, and the head is should be independent from political parties, but he is a well-known. He used to be someone in the past. He used to be a member of the governing political party in Hungary, Fidesz, and he's very loyal to this political side. So he's not independent at all, but he should be by profession. The whole system works quite independently in the ordinary cases. In the ordinary criminal cases, the system works just fine. But we always have the feeling that the really sensitive cases won't get to an indictment sheet, or to they don't reach the court really. So yeah, that's a problem, and it's always very heavily attacked by the opposition that some corruption cases are revealed in the newspapers or by the opposition or by some European Union's institute, and some time passes by, and these cases somehow don't reach the courts. So yeah, that's a problem. But in the ordinary cases, the system is functioning well. So
Okay.
I do not know very much about the function of the system, although my husband is a prosecutor,
So
but
you can't say otherwise then.
I can't say otherwise. Yeah, I could, but yeah. So with this ordinary prosecutors' offices have the same problem like any other offices with resources and salary and everything, but nothing political. There is a separate system among the prosecutors who deal with these sensitive cases.
So they don't have, like in Spain we have unity of actual action. Like if there are other orders from in a case, there might be some orders like how to proceed. That doesn't happen in Hungary.
Yeah. They do. They are the prosecutor is not independent in their choices. He does what the head of his office says to do. So it depends. They have some independence, but at the end of the day, they have united decision, and they do not have their separate cases, so they can substitute, and the final decision is made by the head of the prosecutor office. So yeah, it's
Okay.
different from like being a judge.
I see. And what about in Spain, Carlos?
Well, yes, in Spain, the hierarchy principle, of course, also applies. Although, like you as you were mentioning, in theory, this hierarchy principle, it has to be related to, or should be related to, unity of action. So the aim of the hierarchy is not hierarchy on its own or for its own sake, but it's the hierarchy in order to ensure that prosecutors act in the same way throughout all of the territory, so that, in any given case, a prosecutor does not ask for 2 years imprisonment in Madrid and 5 years in Sevilla. That's in theory what should underlie and what should be taken into account when talking about hierarchy. But apart from that, of course, there is a hierarchy with the chief prosecutor on top. The chief prosecutor, unlike in Hungary, is freely chosen by government. And one of the problems, I think, with the autonomy or the independence of that chief prosecutor is that his or her term finishes automatically when that government isn't in place. So there is this dependence indirect dependence, I guess, between a government's term and the chief of the prosecution. So, of course, if a chief prosecutor wants to be re-elected, for example, by a government, he does not have really the incentive of being independent from the government, because, of course, his or her mandate will fall with the government, and he may or may not be re-elected again by the new government, which may or not may be of the same or the same parties, but even so. And then yes, every prosecutor has to obey the orders given by their superior in every prosecutorial office, as in Hungary, although there is a way to sort of challenge that decision. So if any prosecutor thinks or believes that the order given by their boss is not adequate by any reason, he or she may make that the decision be discussed by a panel of other chief prosecutors. And that panel reaches a conclusion which is not binding for the boss in question. But normally, if this board decides, or that the criteria isn't an adequate criteria, or just disagrees, well, I mean, it's not normal for the boss to insist on his or her first opinion, but in theory he or she still can do that. I mean, the opinion of the board of prosecutors is not binding, so that boss prosecutor can still order whatever he wants to the prosecutor that had promoted that procedure, or he may choose to give the case to another prosecutor, and that's it. So I don't know, I don't have the numbers of how often this mechanism is actually used. I think that normally if the boss disagrees and gives an order, the basic prosecutor just obeys, and that's it. I don't think that mechanism is very oftenly implemented. I guess that is inevitably going to cause some tension within the office, and I don't think anybody wants to be in that position of challenging their boss's decisions. So it's just normal human nature. So.
I would like to highlight some words said by our Prime Minister, or President Pedro Sanchez, who gives orders to the prosecutor, the government, right? So you guess, and that's something that is public. It's a video so public, so humiliating actually for the prosecutors, but it's still.
Yeah, we are actually under one of the most important proceedings in that sense, actually, now with the prosecution of Puigdemont, and whether he should be prosecuted for terrorism or not. And there has been a disagreement between the chief prosecutor and the board of prosecutors of the Supreme Court. So that mechanism is actually being put in action as we speak nowadays. So it's a curious and very important example of that happening. Well, let's see what happens.
Yeah. Adrian, does the judiciary have enough resources in order to do their task in Hungary?
Well, that's quite a highlighted issue in Hungary right now, because judicial associations and the National Judicial Council started to fight a bit more salary, because no, the salary of the judiciary is very poor at the moment, because we had some raises several years ago, but then it totally stopped, and now we have the highest inflation in Europe, and the judicial salaries have not grew in 2 years at all, because the real problem is that it is not automatic. It is not like the officers or employees of the government have some automatic raise annually. depending on the inflation rate. And there is a base salary in the budget for judiciary, and it decides the salary of the judges, the prosecutors, and whole court staff also. And this hasn't grown in the last 2 years, and it isn't in the law that it should automatically grow. And the mere fact that it is the annual decision of the government whether they put in the budget act some race or not, this already ruins the independence of judiciary, because we are not safe in that regard. And now at the moment the basic judicial salary is about 1,400 euros per month, which is not a lot. And in Hungary, basic workers can earn a lot more than a newcomer judge if they I don't know, work at not a factory, but they who build houses, like carpenters, or who are quite well skilled. They can easily earn more than a judge
Judge.
at the and the real, this is a problem already, but what it makes it very, very urgent, that the court staff earn much less, and they leave the courts, obviously, because they can earn more at a shop or anywhere else, actually. And now we have huge problems with court staffs. There is a team, a department at in the Central District Court of Pest, which is the biggest district court in Hungary, and there is a team of, I don't know exactly, 12 or 13 judges. It's a criminal department, and they used to have each judge used to have an administrational staff member. Now the whole team has three. Two of them stated that they resigned, that they leave court. So now they have one for the 12 or 13 judges, which is, yeah, obviously no one can, they have to organize some kind of substitution, but this means that the other teams lack, who lack court staff too, but they have to leave their staff to go to this team and substitute, because someone has to type the judgments, or do the summoning, or I don't know, everything that a court staff have to do. So this is very, very urgent, because the more the workload is on one person in the court, the more likely they will leave. And without quite a huge raise in the salary, they will leave, and they don't have the so much to decide on, because they haven't they didn't go to the university for 5 years and didn't do training program for 5 years, and so on and so on. So it's like an everyday job for them. If I'm not paid, I go elsewhere. But now even judges say that, okay, I can't pay my bills. I can't go on vacation because I can't afford that. So I will leave judiciary. So this is a huge problem now. It used to be
Wow.
better, but now with this, and we always say that how is it that every person who works for the government, not only the ministers, but anyone in the country in offices, like who I don't know, make the identity cards or license plates or anything, they have some automatism in the raise of salary, and not for the judges. It's inexplicable, unless we see that this is a way how our independence can be a bit diminished. Because
Yeah.
we all know that we have to behave in order to get our salary raised. So.
So that's the reason why you don't seek for any kind of trouble. You prefer not to talk, just not to get in danger. Yeah, I guess
That's what we think. This is intentional on behalf of the government, that they don't. When I used to start working as a judge, there was a law that the judicial base salary should be raised by rate of the inflation every year. It used to be that way, and not anymore. So that's it.
Yeah, I agree with you. That is a way of diminishing the judicial independence. You will behave in order to earn your money, because it's not, well, wow. What about in Spain, Carlos?
Yeah, well, I mean, I absolutely agree with Adrian that real independence only comes within financial independence. We say that for any of our children, a child becomes independent when he or she leaves home and is financially independent. Until then, we can't talk about independence. And of course, financial independence is a key aspect of judicial independence. So, I mean, I find what Adrian has told us very, very worrying, in fact. In Spain, the salaries of judges and prosecutors are stated by law. The aim of this was precisely to prevent what is happening in Hungary, that the executive especially wouldn't have, power over the salaries of judges. However, well, I mean, one has to take into account that the executive and the legislative in Spain are two very, very bound powers. I mean, they're not independent one from the other, I think, because, political parties in the end control parliament and form government. So in the end, it isn't that exact or that independent. However, for example, with the crises of 2008, salaries for judges and prosecutors were very, very severely severed as a public spending measure, as well as many other public offices. And salaries were severed by about 20% or something like that. However, and that was deemed constitutional also. And we've reached the paradox that, the government then could diminish our salaries because of the crisis and because of economic reasons. But now, since our salaries are set on law or by law, we have to change the law in order to recover or to have more salary, which is very difficult because judges' salaries isn't on the agenda. So, the fact that our salaries are set by law has only been to our detriment, because when they were lowered, that was okay. And now we have that legal barrier in order to actually raise them substantially. So, but anyway, in every budget law, normally whatever raise applies to the whole of the public sector is also applied to judges and prosecutors. It doesn't match inflation, but at least we do have something of a raise normally every year. A very small percentage. I mean, it doesn't reach. 0.5, I think, is this year. 0.5% of increase with inflation of 5%. So it doesn't make for that, but at least there's something. And since judges have lost about 15 or 20% of their economic power for the last 15 years, and that has been also acknowledged by the Council for the Judiciary, there have been many protests organized by the judicial associations in this respect. And last year, a very, very basic agreement was reached with the government in order to at least recover part of the salary that was, lowered in the crisis of 2010. So we still haven't recovered everything, but at least we have made some progress. And well, there is the promise of, keeping periodical meetings with the Ministry of Justice and the Ministry for public expenses, or the Treasury, in order to advance in these wage issue. So yeah, I mean, we are by far much better than in Hungary. There's no question about that. Yeah.
Yeah, I think you've let us astonished with this information. Like, it was difficult for us to keep on talking. Like, we can't complain about this when we can
Exactly.
hear that what's happening in Hungary. It's like outrageous. Yeah.
Yeah.
Is there anyone who would like to add something else about this topic? Well, you are being very clearly. So we just have the last question. How's the perception that the general public has of the independence of the judiciary in your country? Let's start with Adrian and Hungary, please.
Yeah, as a written, it's hard to say. I know about the country report of the European Commission in 2021, which stated that the perception of independence of the courts has deteriorated, and it's 37% of the public rated it as bad, 40% as good or very good, and 22% had no opinion on the matter. So that's a number I have, but. First of all, the bad opinion is always louder than the good opinion. So if we read articles or even comments, it's mostly the bad opinion. And the courts are attacked because of the length of the proceedings, because there are always, we all know that there are always proceedings that take quite a huge amount of time, but the vast majority end within a year or within 1.5 years. But the ones that reach the public are the ones that are the most difficult cases that last longer. So that's understandable that the public has this perception. The other thing that there is no such thing in Hungarian schools. No, they don't learn how to be a citizen, and judicial or independence and rule of law related question included. And that's what we try to do in my association, that we go to schools and we hold lectures and we talk about the whole court system and the importance of independence of the judges and the court, and the basic knowledge of law. If you turn 14, your status changes, what you may do, what you may not do, and such things. And we hold seminars at universities, and we organize discussions and workshops with the society or for the society, for civilian people, just to talk about it, because they don't know. For example, there is, maybe you know, this the association Mensa, which is for people with higher IQ, who has a higher level of IQ. They can be a member of Mensa, and we have a series of panel discussions with them in Hungary. And I was there the day before yesterday, and we were talking about the responsibility of the leaders of companies. So, because many of them have their own small company, but most people don't know what are the responsibilities. If I work as a leader of a small company, my own enterprise, then I have some responsibilities. And then we went there, two judges and a lawyer, and then we were discussing this. And I think this is very important. We're a small association and we don't have the capacity to go everywhere, but we start step by step. And now in Budapest, we are invited to quite a lot of schools to, there are always these days for how to choose what do I want to become. So some orientation days. And at the school of my daughter, it was called Market for the Boomers, because the parents went there and they all were talking about their profession, and I went there, and I think this work may a bit change the perception of the independence of courts. If people see that we are not just sitting there on bench and say our verdicts without an explanation, but go there and try to explain ourselves. So that's it.
That's nice, actually. What about Spain, Carlos?
Well, in Spain, situation is very similar, I guess, to Hungary. I also have the figures of the last country report of the European Commission for 2023, and it says that the level of perceived judicial independence in Spain continues to be low among the general public, and is now average among companies. Overall, 38% of the general population and 41% of companies perceive the level of independence of courts and judges to be fairly or very good in 2022. So, well, yeah, I guess that perception of independence is not very high. No wonder, given the spectacle of the Council for the Judiciary and the political fight about the Council for the Judiciary, because of course, since the general population doesn't have any knowledge of their institutions, this is something, in Spain, like in Hungary, people don't distinguish between the Council for the Judiciary and the judiciary itself. So of course, people see, how politicians are fighting over the control of the council constantly, and that translates to the whole of the judiciary. So I'm not surprised that the perceived independence of judges is very, very low. Nobody knows in Spain that the Council for the Judiciary cannot influence any particular judge or cannot issue any orders to any judge or court. But people don't know this, and this also links with the lack of education in these matters. In Spain, students in schools or university, they don't learn about their institutions. They don't learn about rule of law, separation of powers, about the role of the judiciary, the constitutional courts, the parliament. They don't learn about any of this. So this is, yeah, very, very difficult to change. We also try in our association to go to schools and hold conferences about these issues with students of 16 years old, maybe, I guess. uh, but of course this is just not enough. I mean, we cannot substitute the teachers, and we cannot cope with all of them. I mean, we would wish we could, but I think that we should press the education authorities in this sense, and make them realize that education in this field is very important in order to make citizens, out of students. But yeah, I mean, it also education in Spain is divided into the autonomous communities, the regions. So, some regions may be more eager to implement these ideas, some maybe don't. And well, it's difficult. And I don't know whether our talks in schools will change perception, because I mean, and if it is, I mean, this can only be assessed in the very long run, in the long term. Uh, Whereas I think that immediate action is very much needed in this regard, because the population is constantly being manipulated by all political parties, and it is easy to manipulate who doesn't have any knowledge about how things actually work. So yes, it is a big issue, and we also work a
Actually,
lot in.
I think in Spain it's getting like worse because we've been attacked like on a daily routine. There are attacks against the judges from the executive and legislative powers, like saying that we are sexist, we are not going to believe any woman, which is kind of ironic because it's precisely what the aggressor says to the victim in order for her not to sue, not to get out of this situation. Or maybe that we are just we are issuing our resolutions because of political interest, which is also ironic because if we were obeying, they wouldn't be criticizing us. And they are saying something that we do lawfare, which is new for us. That there was some initiative. Let's hope it doesn't get developed, in which there will be a parliament committee trying to assess if a judge committed a crime. So that's kind of ironic. The judge is judge. So if the parliament also judges, there's no separation of powers. So that's the point where we are arriving, and I think that's affecting the public opinion too.
Yeah.
But I must agree with Adrian. Maybe I need to do it, but I need to believe that what we are doing with the project that we call Ambassadors of Justice is working, because there must be some hope, because I cannot get retired. So I need to have hope. Sorry for interrupting you, Carlos.
No, that's quite all right. Yeah.
We have the same problem because judiciary is not has not got used to defend themselves. So we don't step up, we don't go into the public, we don't explain ourselves, and there are from time to time there are judgments which are controversial and which are heavily criticized by the executive, and we don't go there and say, hey, that's not your business, it's not your task to it's obviously, a judgment may be criticized by the public, by a newspaper, a journalist, an academic, but not the separated executive power, I think. And it happens time to time. And sometimes there are some controversial law which is enforced by the judiciary, obviously, and now the members of the executive come and say that it's outrageous what judges do, and they do not mention that this is the law they made, what we are now implementing because we have to. And this is happened right now, quite recently, last week actually. There is a criminal case which includes a woman from Italy who is arrested in Hungary right now. And in Italy, there was quite a scandal that they saw on television how this woman was transferred to the court in handcuffs and cuffs on the ankle too.
Mm-hmm.
And it was shown in the media, and the whole Italy raised up and said that this is against human rights and how is it possible. And the executive on our behalf, on Hungary's behalf, said that we have nothing to do with it, this was the court's decision, we can't help. Maybe they also said that, yeah, this is unfortunate that this happened. And the fact is that the law says that the judge may not decide about the measures that the prison takes in order to transfer a prisoner from the prison to the court. So I know a judge may only order to remove the handcuff, but not the others, like on the ankle and the other security measures. So they actually lied to the media and to the Italian authorities, and they push the burden on the judge, who may not decide, even if they want to, about these measures, which is not good, I think. And the prison, the head of the prison, mostly or quite often chooses such security measures that are really unnecessary, because they want to be safe. They don't want to risk that someone escapes, because then it's their fault and their responsibility. So it's quite often that, in my opinion, they use more severe measures while transferring the arrested people to the court than necessary. But the judge may not tell otherwise. So I cannot tell the guard that they should remove these cuffs on the ankle, for example.
What you're
That's
saying is very right, because that happens to us in Spain with other cases, but it's the same. It's like if we had a representative who would explain that would explain the law, the competence, like how is the proceeding and what we can do and what we can't do, which is more important, because sometimes, as you say, there might be some a slight problem, but we don't have that, so we are alone. And right now in Spain is the judicial associations who are going to the media and answer questions when it's that's a kind of difficult for people who are a little bit shy like me. But we are trying to explain to the public that's not a competence of the judiciary. But we do need that the General Council of the Judiciary has that person that can deal with that, like a special controversial cases that can be explained by someone who knows the law and try to explain what the case and the proceeding and everything is about, and not just being alone, because I know being a judge is lonely, but it doesn't mean that we have to be this alone.
Yeah.
So, you know, all of you, that we've acknowledged all the problems that we are dealing in the rule of law across the European Union. We would have liked to have Germany, but the person who was supposed to come had personal issues and couldn't be here, unfortunately. So, but the thing is that we are working on a project called the Statute of the European Union Judge, and we would like to keep on moving on that regard. That's the reason why we want to gather as many people as possible, even if we have to repeat this experience, which have been a delight. Thank you, Adrian and Carlos. And before giving some period of time for questioning, I would like to highlight this institute for it to be well known and maybe get to the European Parliament for it to be approved a soft law. That could be our ideal, and that could be the minimum that the governments, the member states should respect in order to guarantee judicial independence. And among other things that we've heard today, I think financial independence is the key of judicial independence, as we've seen what you've told us, not only for judges, but also for the people who work with us. So if anyone else want to say something, share something.
I just would like to ask what procedure do you plan? How would you like to invite other countries, other associations? Do you have a plan already, or how can we help, for example?
I think we should get to gather all the data we have from other judges and prosecutors from all over Europe in order to create more experiences like this, like these small debates where we get to know the differences and also the points that we have to work with in common, like this representative, financial independence, and maybe some other issues that are not our common ground, but we should know about it. Like the staff, like you are understaffed. That's not only affecting your salary, but also the salary of the people you work with, and you cannot do your work if you don't have a person who's doing the summoning. That's like basic thing. I can't do my job if I don't have a justiciable who needs me. So I'm starting with this, gathering all the information, making the discussions, and get it to be well known. And actually, I've been this morning in a European Parliament commission speaking of this institute. Let's hope that this just thinking and they want us to get working like this on this one, but we'll see.
Okay.
But thank you for all your for your will to help. And also, if you have some ideas, we are all willing to find new courses offline, because it's just difficult. It's an individual to individual kind of situation. And if we could get all the judicial association across Europe, that would be amazing.
Yeah, okay. If you we are members of MEDAL too. There are quite a lot of associations, so we can reach them. If you want, we can help, or maybe through EJTN also you can reach people. Yeah. So yeah, if we can, we help. And if you need any additional information about our system, then I'm willing to give. So just
thank you very much.
let's keep in touch.
And anybody else want to add something else? I guess you were so clear that, yeah. No, I guess you were so clear, guys, that no one had to make any questions. It was so nice of you to spend this time of the afternoon with us to tell us your difficult experience in your countries when it comes to do your job. And I hope it gets better. I really do. So thank you.
Thank
I guess we
you.
can finish.
Thank you. Bye.
Thank you. Goodbye.
Bye.
Thank you.